this webinar on the case of Rihan and Ernst & Young Global Ltd and others. It's great to see the level of interest in this case, which represents an interesting new development in the law of tort, particularly for UK organisations providing professional services overseas and workers who raise ethical or regulatory concerns in that environment. So I'll describe the facts of the case in more detail shortly, but by way of a very brief outline, this is a case in which I, alongside Daniel Leader, a partner in Leigh international department, fellow partner, represented the claimant in a civil claim against various legal entities forming part of the EY network of member firms, which, as most of you will know, is one of the big four global accountancy and professional services organisations. Now, the case concerned allegations that EY had covered up the adverse findings of a sustainability audit into the Dubai gold trade, including evidence of money laundering and conflict minerals, causing the claimant, who was the partner in charge of the audit, to resign. Now, after the trial, Mr. Justice Kerr ruled in April 2020 in favour of the claimant and found that senior EY global executives had consistently acted in breach of the relevant professional and ethical standards when dealing with Mr. Rehan's concerns. The court awarded the claimant $10.8 million subject to adjustment for tax in damages. Now, EY filed an appeal, which was subsequently withdrawn in December 2020 and was then formally dismissed by the Court of Appeal on the 31st of December 2020. I am very pleased to be joined today by Ben Hubble QC of 4 New Square Chambers, who was lead counsel for the claimant in this case. And I'm also delighted to be joined by Mike Cain, an associate solicitor in Leigh employment department, who will be lending us his expertise on the statutory protections for whistleblowers under UK employment legislation. Now, as we will come on to in due course, this case was not a statutory employment claim, but the interplay with the statutory scheme did form part of the judge's reasoning, and we thought it would be helpful for Mike to give us a whistle-stop tour of the statutory protections before we delve into the detail of the Rihan case itself, including why Rihan fell outside of the scope of the whistleblowing legislation and how the court referred to and relied upon the statutory provisions in its analysis. Now, I appreciate there may be a broad spectrum of attendees today, and the judgment is a long one, and we recognise that whilst the brave amongst you may have read it cover to cover, some may have a more cursory knowledge of the facts of the case and the court's findings. So after Mike has provided his overview of the statutory protections, I will give a summary of the key facts and issues in the case before Ben delves into the detail of the court's ruling and its implications. I'll hand over to Mike, who will kick us off with some background on the statutory scheme applicable to whistleblowers under UK employment legislation.
Okay, thanks, Paul. Good afternoon, everybody. Given, as Paul says, that Mr. Justice Kerr's thinking in the judgment in this case was shaped by a distinct awareness of the possibilities under UK whistleblowing law, and more crucially, the non-availability of those options for Mr. Rehan. We thought a quick tour of the UK and GB whistleblowing space would provide a useful form of contextualisation. That said, I've been asked to cover UK whistleblowing in a 10-minute window, which the employment lawyers present will know is a very tall order. So it is to them in particular that I apologise first, because they, as a group, are unlikely to learn anything new from my overview. But I take comfort from knowing that those particular colleagues primarily seek, as I do, to benefit from hearing about the Rihan judgment from its originators. Now, if you'll bear with me with the slides for a moment. It should also be said that in inversion of the usual rule, the slides will have more content in them than what I actually say this afternoon. And if anyone wishes to take up any points with me that they find on the slides or generally as part of the Q&A afterwards, I'm happy to be contacted. So, having taken a 4 Ws approach as part of this whistle-stop tour, I should start with the what and clarify what whistleblowing is and what types of claims can be made as a whistleblower in the UK. The two forms of claim available are a claim by a worker or employee that they've been subjected to a detriment on the grounds of having made what is technically known as a protected disclosure, or a claim by an employee that their dismissal is automatically unfair because the reason or principal reason for dismissal is the fact that they have made a protected disclosure. What then is a protected disclosure? Well, we can turn to the definition in section 43B of the Employment Rights Act, which reads fairly easily. A qualifying disclosure means any disclosure of information which, in the reasonable belief of the worker making the disclosure, is made in the public interest and tends to show one or more of the following: that a criminal offence has been committed, is being committed, or is likely to be committed; that a person is failing or is likely to fail to comply with any legal obligation to which he is subject; that a miscarriage of justice has occurred or is occurring or is likely to occur. You can all see the pattern. That the health or safety of an individual is being or is likely to be endangered; that the environment is being or is likely to be damaged; or that the information tending to show any matter falling within any one of those preceding paragraphs has been or is likely to be deliberately concealed. Well, looking more closely at those particular provisions, the need for any qualifying disclosure to be in the public interest is something that's been specifically introduced as a condition to address what was the proliferation of claims arising out of narrowly defined personal contractual disputes. Notwithstanding this, and probably thankfully, given the public significance of the contracted role of many groups of employees, there is still no bright line that separates public and individual interests, as the case law has shown. There's also been an equally lengthy period spent by the courts delving into the distinction between the claimant providing information containing facts, which is required for a protected disclosure, and the expression of mere opinion or allegation, which isn't. Now, whilst the majority of disclosures will be made to an employer, Part 4A of the Employment Rights Act allows for several of the routes of reportage for a disclosure, including to the various prescribed regulatory bodies in the sector. And exceptionally serious failures do have looser conditions for reportage. The reportage requirements for whistleblowing are a feature which understandably receive less attention as a perceived technicality, I think, than the subject matter requirements, and the more casual attribution of the whistleblower epithet in the general media keeps the focus on content and not method of disclosure. But it does remain entirely the case that disclosures can lose protection through a failure to meet the conditions for reportage within the provisions. Now, another important point to note is that any attempt in a settlement agreement or NDA to prevent an employee on termination or a worker from making a protected disclosure thereafter is, by operation of statute, null and void. A point less commonly made, though, is that there is nothing to prevent a settlement of a detriment or other whistleblowing claim based on facts which precede that very agreement. So, a claim of detriment, that's the first of the two types of claim, is not only available to employees, but is also available to the increasingly widening category of workers. Neither is it limited as a claim that can only be brought against the employer, as we shall see. Now, where claims are brought against another employee or worker of the employer, vicarious liability will attach to the employer for the acts of the other individuals, unless the employer successfully shows itself to have taken what is known as the all reasonable steps to prevent the conduct complained of. Detriment. What is detriment when we talk about a claim for detriment? It's not a statutorily defined term, but the long-standing definition from the House of Lords in 2003 is clear as to how low the threshold is for a detriment. Anything that objectively viewed would amount to a sense of having been disadvantaged will suffice for the claimant. No monetary loss is required, but the circumstances resulting from the conduct have to amount to more than what Lord Hope, begging several questions, I would say, described as an unjustified sense of grievance. It's a very low threshold, and it's an objective test. Just returning to the question of who it is that can bring a claim to detrimental treatment and what worker can mean for the purposes of bringing a claim. We have highest authority clarifying now that, in fact, contractee status, despite the wording of the statute, is not even fundamental. Equity partner LLP members, for example, have been clarified by the Supreme Court as falling within the intended worker definition in Bates van Winkelhoff. And most recently, and spectacularly, office-holding judges have been allowed to benefit from inclusion in the category to ensure that ECHR obligations are complied with. By contrast, the automatic unfair dismissal claim option of the two is only open to employees and apprentices. But where it becomes available on the given facts, its comparative advantage over a standard unfair dismissal claim includes the fact that it's not necessary to have 2 years service to bring a claim as it would be with ordinary unfair dismissal. Causation, of course, is always the factor of differentiation and the most common evidential stumbling block for a claimant. The Supreme Court's hugely significant clarification in the case of Duty and Royal Mail in the last year that hidden reasons harboured by a retaliatory line manager, even when not known to the dismissing officer within an organisation, can trump the invented reasons for the dismissal, can't really be overestimated as a case that will assist in claiming for automatic unfair dismissal in relation to whistleblowers. If you think about the politics that can internally arise in an organisation in line management relationships. Now, both sets of claims must be raised in the employment tribunal or in Northern Ireland in the industrial tribunal within 3 months of the act complained of or last act of detriment in any sequence, or in the case of automatic unfair dismissal, the effective date of dismissal. In both cases, early conciliation, in Great Britain through ACAS and in Northern Ireland since January this year, through its own equivalent provisions, is a pre-claim requirement and can extend limitation for some weeks where it's commenced before the core 3-month deadline. Whilst extensions of time for those outside the core time limit are theoretically possible, the likelihood of an extension being granted is extremely low compared to the slightly softer rules that exist for extensions for claims under the Equality Act. Compensation and remedy for claims in detriment are unlimited and allow for damages to injury to feelings, as in discrimination claims. And it's not particularly contentious to suggest that where a claim succeeds, the damages under this heading are unlikely to be in the lower categories for injury to feelings. They're likely to start at the beginning of the middle category at around 10,000 or more. Automatic unfair dismissal claims for employees do not result in injury to feelings. But as well as having no minimum service, as I mentioned earlier, there's no capacity on the ability to recover compensation for lost earnings damages, as would be the case in an ordinary unfair dismissal claim. And one of the most stunning and far-reaching judgments in respect of whistleblowing remedy from November 2018 is the case of Timmis and Ossipon, which I think will have very far-reaching consequences. It effectively took a wrecking ball to the previously rigid distinction between the ability to claim damages arising before dismissal for detriment and detrimental treatment occurring before or short of dismissal on the one hand, and the ability to only pursue post-dismissal losses from the employer in automatic unfair dismissal on the other hand. Now, any number of culpable individuals within the claimant's pre-dismissal space could face hefty lost earnings claims in their own right for causing or contributing to the detriment of dismissal. And one can see that that is going to be a fairly seismic development for future cases. Last, but most definitely not least in the present context, as Paul suggested, is the question of jurisdiction and scope and the availability of whistleblowing apparatus to expatriate employees. Now, the House of Lords in 2006, in Lawson and Serco, which was the locus classicus case at that time, said that availability for expatriate employees would be exceptional. 6 years later, the Supreme Court in Rihan clarified this further by saying that any expatriate claimant would have to show a stronger connection to Great Britain as a forum for litigation than the locus of where the work was being carried out, and the assessment required was by reference to factors including nationality, place of recruitment, and place of location of employer. Subsequent Supreme Court cases have clarified that there is only a lowering of this threshold possible where any given expatriate employee spends time living or working in the United Kingdom. That was the case in Rihan, it was the case in Bates van Winkelhoff. Now, in conclusion, it would seem trite to say that Mr. Rehan, had he been within scope with a UK employer, his detriment claim would have been a very robust one. It could have extended to the key individuals that are going to be mentioned as dramatis personae in his case in this talk. His partnership status would have precluded a claim under the automatic unfair provisions. But that, as we've just been hearing about because of the Timmis case, may have proved academic, given that he would have been able to bring such a robust and potentially high-value claim had he been within scope, which, of course, very significantly made clear wasn't. So, with that rapid and inevitably superficial précis of what is a massive and expanding area of claim, I'll hand back over to Paul so that he can talk a little bit more about the key judgment and focus.
Thanks very much, Mike. I'm just going to sort out the screen share just in a moment. Good. So moving on then to the facts of the Rehan case. EY was engaged, EY in Dubai was engaged to conduct an assurance audit on a Dubai gold refiner called Kaloti Jewelry International. And Kaloti was the most substantial gold refiner in Dubai, holding the largest market share, approximately 50% of the market there. And the claimant was the engagement partner for the audit, so he was responsible for the audit, and the purpose of it was to provide an independent written view on Kaloti's business and gold sourcing practices. A clean audit. A clean audit would have enabled Kaloti to receive accreditation from regulators, international regulators, including the Dubai Multi-Commodities Centre, the DMCC, and the London Bullion Market Association, so a London-based gold industry regulator. And the audit was going to be conducted against standards laid down by those regulators. Following the audit, the idea was that Kaloti was supposed to publish a compliance report, which would then be endorsed by EY, confirming its veracity, and that compliance report would set out the extent of Kaloti's compliance with the applicable standards of the DMCC and LBMA. So moving on to what Mr. Rihan and his team found, the audit findings, and by sort of mid-2013, which is when the audit was taking place, he and his team had uncovered a number of serious issues within the audit client, amongst which were the following. The key one, which was central at the trial, or became central at the trial, was what came to be termed as the Morocco issue, which was that Kaloti was knowingly dealing in gold bullion smuggled out of Morocco, coated in silver, to deceive the Moroccan authorities into believing that it was silver, thereby avoiding restrictions on the export of gold. The silver was then declared to be gold upon arrival in Dubai. So that was a Morocco issue. There was then the cash issue, as again it was termed at trial, and that was that in 2012, which was the review period for the audit, Kaloti had taken part in cash transactions in gold involving about 5.2 billion US dollars. And then finally, there was the issue of conflict minerals. This type of audit was commonly known as a conflict minerals audit because one of the key components of it was to assess the extent to which Kaloti was trading with countries where there were issues of armed conflicts, and where consequently the trading in gold would carry an increased risk of being traded for the purposes of financing terrorist activity or organized crime. So these findings gave rise to a reasonable suspicion that Kaloti was engaged in money laundering, and the defendants indeed accepted at trial that suspicion arose. The audit findings, continuing with that theme, moving on to the pressure that the client subsequently received from the DMCC and Kaloti. What happened is that after uncovering these issues and meeting with the clients, Kaloti reacted very angrily, protested vocally about the findings, and insisted that the matter be referred to the DMCC, which indeed it subsequently was. And the DMCC's reaction was to express concern that the findings against Kaloti would damage Dubai's image internationally and could adversely impact on the gold trade and Dubai economy, and the trade in gold being a significant contributor to the Dubai economy. So the court found that the DMCC placed in what it described as improper pressure on the claimant to reduce the cash and Moroccan gold issues to what the court described as vanishing point. An example of this was the DMCC asking the claimant whether changing the review period of the audit, this was after the audit had already commenced, or indeed had been completed, whether changing that review period would impact the rating positively, the rating being the final rating that was awarded to Kaloti. So the matter then escalated. The claimant escalated the issue to senior, or these various issues to senior EY executives based in Europe who were acting on behalf of the defendants. And the defendants were various governing and service entities in the EY network, UK registered entities. And those senior executives, rather than supporting the claimant in resisting the pressure that he was coming under from Kaloti and the DMCC, instead made and developed proposals which amounted to collusion with the DMCC's agenda of protecting Kaloti from the publication of the damaging audit findings. And those proposals included, amongst others, firstly proposing that the audit period be amended mid-audit in order to avoid reporting these damaging findings, removing reference to Morocco in the audit report and changing the reference to the coating of gold bars with silver to documentary irregularities. And thirdly, failing to indicate the scale of the cash transactions, $5.2 billion, which was obviously critical in terms of the associated risk of money laundering. And fourthly, accepting accounts from Kaloti regarding the Moroccan gold, which they knew to be untrue. And then finally, endorsing final reports, which the court found to be clearly misleading because they avoided any attention being drawn to these damaging findings. So what was the impact of all of this on the claimant? Well, whilst all this was going on, he left Dubai, fearing for his safety, having not received the institutional support of EY. He was left isolated there in resistance to the DMCC and Kaloti. And the DMCC, I should add, is an arm of or part of the Dubai government there. And given the human rights concerns of coming up against the Dubai authorities, as he was now doing without the support of his organization, he had fears for his family and his safety and left Dubai and came to London. And he met subsequently then with various executives in London and elsewhere in Europe. And the court found that he was subjected to improper pressure by these individuals, intimidation, threatened with adverse career consequences if he didn't go along with their proposals, including threats to his partnership, and was accused of lacking professionalism. So in the face of all of this, the claimant ultimately felt he had no option but to resign from the organisation, disassociate himself with what was happening, and put the findings in the public domain. And he did that via a report by an NGO and also through some media entities. Now, after going public with the findings, the claimant was unable to obtain further employment in his industry sector and suffered considerable loss of income as a result. He was a high flyer operating in a tax-free jurisdiction whose earnings at that time were on a steady upward curve, and indeed he had built a business there really from scratch out in Dubai in terms of sustainability audits. So finally then the issues in the case. The claimant was a partner in EY MENA, which is a UK company, but it was not a defendant in the claim. The defendants, as I said, were these UK-based governing and service entities on whose behalf the claimant's interlocutors in the case acted. So the claimant had no contractual relationship with the defendants, so no employment or contract claim arose, referring back there to the parameters laid down by Mike. So the key issues were, could the UK governing and service entities in a corporate network be liable for financial loss to an overseas partner of a member firm, despite there being no contractual relationship between the two? Secondly, if such liability could arise, what was the nature and scope of that duty? And in particular, a key question that arose at trial was whether it was sufficient for the defendants to simply follow rules set by the Dubai regulator, which the defendants argued at trial it was. Thirdly, could any such duty exist alongside the existing statutory framework for whistleblowing that Mike has outlined? And fourthly, was the claimant's public disclosure a novus actus? So did the fact that the claimant went public with what at the time certainly were allegations, did that fact break the chain of causation so as to deny him an actionable claim? And that is certainly what the defendants argued. They claimed that he was effectively the author of his own misfortune in going public with these issues, and that's the loss of earnings that he subsequently suffered as a result of his ability to or inability to obtain employment were his own doing. So those are the facts and issues. I will now hand over to Ben, who will talk you through the findings of the High Court.
Hi, good afternoon, everyone. So thank you very much to Mike and Paul for their introductions. I'm going to spend 15 minutes or so just looking at how the judgment works structurally and what the particularly interesting points are that come out of the judgment. And as Paul has done, I'll be working from the facts as found by the judge in the judgment. The first thing to identify is actually who the parties were to the claim. Mr. Rihan, the claimant, as we've heard, was in effect a member of EY MENA, which was an entity registered in the UK, but was the firm that operated in the Middle East and North Africa. So that's MENA. So Mr. Rihan was a partner in that entity, but he was working for a local branch called EY Dubai in Dubai. So he was based in Dubai, working for EY Dubai, carrying out the audit of an entity in Dubai. Who were the defendants? Well, the defendants were UK LLPs or companies that formed part of the EY network. And there were 4 defendants. EY Global, which was the coordinating body for all EY member firms globally. EY Europe, which was the service company that operated to support member firms across Europe. That entity was a member of the ICAW, which is the regulatory body for accountants. Third defendant was EY EMEA Services, which was the service company for the EMEA region, of which EY MENA was part. So EMEA, Europe, Middle East, India, and Africa. And D4, EYGS, EY Global Services, was another provider of global services to member firms across the globe, including at the request of D3, which was EY EMEA Services. So the central point I want you to take away from this slide is that this was not a situation where Mr. Rihan was suing his employer that was based, and as a result of his work in Dubai, he was suing the service or governing entities of the EY network who were based in the UK. Who then were the witnesses? The claimant himself, Mr. Rihan, his wife, Miss Montford, and then 3 individuals, Mr. Otti, Mr. Labode, and Mr. Heller. And again, the point of some significance of these were all individuals. So the witnesses who were called on behalf of the defendants were people with senior management positions who had acted on behalf of these entities in their dealings with Mr. Rihan.
Oh, yes. There we go.
Yeah?
Yeah.
Okay. Don't ask me what happened there, but anyway. So where was I? I was on the witnesses. And the central point was that the witnesses in question were all called from the entities acting on behalf of D1 to D4. And then what did the judge find? Well, remember that the defendant's position at trial was Mr. Rihan was not a partner or a member of any of the defendants that were before the court. So they said, well, no duty was owed to Mr. Rihan, and rather any duty could only have been owed to him by EY MENA, of which Mr. Rihan was a partner. And the defendants relied on the structure of the EY network and argued that the member firms were independent and were not controlled by the defendants. Now, the judge didn't follow a traditional Vedanta parent company subsidiary type analysis. So he didn't say that the parent company ended up taking on a sort of supervisory role of obligations that were owed by a subsidiary. And the judge was at pains to make clear in his judgment that one had to look at Mr. Rihan's case quite differently, because his claim was for pure economic loss. This isn't a situation like an oil spill into a river or causing a personal injury. This was a pure claim for financial loss. But what the judge did do is he simply made findings of fact that the defendants took control of the Colotti audit. And remember, the Colotti audit was being undertaken by EY Dubai locally. So the judge simply found that the defendants took control of the Colotti audit as a fact. And then separately, he went on to ask himself the question whether in the circumstances the defendants, having taken control of the Colotti audit, owed a duty of care to Mr. Rihan. And so, for instance, at 584, as I cite there, the judge found that I regard the knowledge and perceptions of Mr. Otti, Mr. Labode, and other global and regional leaders as attributable to all four defendants for this purpose. The EY organisation at global, regional and local levels acting in concert with and through its various subordinate associated bodies in the manner envisaged in the written agreements. So the judge, in a sense, just simply cut through the issue of the particular structure of the network and said, well, these defendants took control. And in terms of what are the takeaways from that approach, first of all, it's right to identify the defendants disputed the case on the facts at trial. They certainly don't accept the judge's findings of fact or law. But what the judgment shows is that findings of fact are vital because they're the framework within which the law is applied, and they are extremely difficult to appeal. And what we saw here is that you can have a complex structure, but that won't prevent head office type entities being potentially liable to a partner or a member or employee of a member firm if, as a matter of fact, they take and exercise control. What was the duty of care that the defendants owed to Mr. Rihan? Well, Mr. Rihan argued at trial for two related duties, and they became quite sort of separate labels in the course of the trial. One was called the audit duty and one was called the safety duty. The judge found that the defendants were quasi-employers of Mr. Rihan. So again, in essence, a factual finding that the defendants stepped into the shoes of being Mr. Rihan's employer. But remember, this was not a personal injury case. This was an economic loss case, a claim for pure economic loss. The judge rejected that the defendants owed Mr. Rihan the safety duty. So that's a duty, in essence, to protect Mr. Rihan from the danger of suffering harm in the workplace or safeguarding his position. The judge, viewing it very much from an employment or personal injury law analysis, said that it would be an illegitimate extension of the law to leap from an employer's duty to safeguard an employee against personal injury to a duty to safeguard them against pure economic loss incurred due to a claimant's need to cease working to avoid a threat to his physical safety. The judge also rejected the contention that the defendants owed the audit duty by way of assumption of responsibility. So that's the idea that one party can assume a responsibility in law to another. And the judge took the view that, as this was an economic loss case and wasn't within Hedley, Byrne and Henderson, that this was not an assumption of responsibility case, which was certainly one of the ways that the claimant put it at trial. Because there was no assumption of responsibility that extended to Mr. Rihan's post-employment earning power. But the judge accepted a novel duty of care owed by the defendants to take reasonable steps to protect Mr. Rihan from economic harm in the form of loss of earnings by reason of the defendant's failure to conduct the Colotti audit in an ethical and professional manner. And remember that where this case started is that Mr. Rihan was working for EY Dubai, but because the defendants stepped in and took control of the Colotti audit, it was the defendants who ended up owing a duty to Mr. Rihan, even though he wasn't a partner or employee of the defendants. Now, what was the audit duty as found? Well, the judge concluded that a quasi-employer, even when there's no contract, can come under a limited duty in tort to take reasonable care to protect the post-employment economic interests of the quasi-employee. And the strong findings of fact made as to collusion by the defendants weighed with the judge. He identified 9 principles of law. One of them was that the law gives weight to the quality of the defendant's conduct. It's a pointer towards a duty of care if the conduct is immoral and unethical and causes serious and unjustified financial harm. And so against that background, the judge applied the traditional caparo requirements in order to see if the circumstances had been met to establish an extension to the law of tort, a novel duty. So against that, he looked at the questions of foreseeability, proximity, and what was fair, just, and reasonable. And again, the moral element played on the judge's mind here. We see at 603, if the defendants owe this duty, they will only be required to do what they are in any event bound to do as a matter of professional ethics, which accord with generally accepted views of morality in the context of reporting exercises such as this one. What are the limits of the audit duty as found? This takes a little bit of unpicking. The judge saw this case as being within a small class of exceptional cases, which in essence employment cases about providing a working environment free of unprofessional conduct and so forth, Scally, Spring and Mahmood, where a quasi-employee is protected against financial loss after the end of the employment. And the extension comes really here at 621, where the judge says he sees no reason why in certain circumstances the moral and professional integrity of the quasi-employee should not be protected by a duty to take reasonable steps to provide an ethically acceptable work environment free of criminal conduct and free of professionally unethical conduct. So that's not a duty owed to the client. That's a duty owed to your employee or your quasi-employee to take reasonable steps to provide an ethically acceptable work environment, free of professionally unethical conduct. Now here we get the twist, going back to what Mike was talking about earlier. Mr. Rihan, being a partner in EY MENA and working outside the UK, did not fall within the Employment Rights Act 1996 or its statutory regime for whistleblowers. So he didn't ordinarily work in the UK, so he did not have the benefit of that statutory protection. But the absence of that statutory protection was important in the judge concluding that it was appropriate to impose a duty of care in these particular circumstances owed by the defendants to Mr. Rehan. Got a dog going mad next to me. Let's see if he settles down. The judge would not have considered it reasonable to impose the audit duty in circumstances where Mr. Rihan couldn't avail himself of that statutory protection. Now, the judge's view was that this duty would only apply in very narrow circumstances and that the present case should be regarded as an outlier with a factual basis that will rarely, if ever, recur. The point that I identify is to be hoped the judge is right about that and that these facts will indeed never recur. But the upshot is, if Mr. Rihan had been working in the UK and so would have had the benefit of the ERA, this separate claim in tort would not have been available to him. But the flip side of that is that on the face of it, applying the judge's judgment, if you have coordinating head office entities based in the UK of any large business or global professional services network that take control of an underlying activity being conducted by a member firm anywhere around the world, then that head office entity based in the UK can end up taking control of the ethical working environment of that partner or employee of the member firm, even though there is no direct employment relationship. So it ended up being an important element of Mr. Rihan establishing his claim against these defendants precisely because he was not ordinarily working in the UK and did not have the protection of the ERA. Next, an interesting question is, how do you define and apply an ethical duty? What the judge did was he applied the International Code of Ethics for Accountants, the IFAC code, and he took that as his set of principles to apply in deciding whether conduct was ethical, proper and professional. Now that code, and those of you who are familiar with the regulation of accountants will know that it's the international code which is the source of the ICAW Code of Ethics, imposes amongst other things principles of integrity and objectivity. And a really quite a significant or potentially significant finding by the judge was that the obligations imposed on the defendants by the IFAC code obligation principles of integrity and objectivity trumped the rulings or dealings of the local regulator. And 679, the proposition that there is no higher authority than the DMCC as a regulator, so that's what the defendant was contending for, must be emphatically rejected. I conclude that an audit may be ethical by the standards of the country where it is carried out, but unethical by the standards of the IFAC Code and the law of England and Wales. So you have a situation there that is potentially really quite far-reaching, because the standards imposed on UK entities when they're dealing with local regulators, those UK entities are going to have to stand back and reflect applying international standards, IFAC code or in effect the ICAW code, applying those standards. Is it appropriate to act in accordance with the stance that's been adopted by the local regulator? Now, it might be said that this is quite an extreme case on the facts as found by the judge, and so that ruling is not surprising, but actually it has potentially really quite far-reaching consequences. Causation and remoteness of damage. Was Mr. Rihan the author of his own misfortune and financial loss by resigning and making a public disclosure to media organisations? Well, the judge's answer to that was no. The judge's conclusion was that Mr. Rihan didn't act unreasonably in making public disclosures. Indeed, as the judge says at 815, as for disclosure to the media being a last resort, in my judgment, the claimant can fairly say the point of last resort had been reached. And there, again, picking up on the position with on what Mike was talking about earlier in paragraph 813, we sort of had a shadow boxing debate about whether what Mr. Rihan did in making disclosures would have been a protected disclosure under Part 4A of the 1996 Act. Because the defendant's position was that Mr. Rihan, by making a disclosure on a non-anonymized basis, caused his own loss. And the response taken on behalf of Mr. Rihan in response to that was to say, if Mr. Rihan had been making a claim under the ERA, this would have been something he was entitled to do by way of a public disclosure. And if that's right, and this is something that would have fallen within an English law statute, it can't be right that English common law could allow someone to be penalised for doing that. So that's where some of these issues that arise under the ERA do play out through the judgment, and the judge looks at that with great care in the judgment, even though in fact this isn't a case under the ERA. So what are the conclusions that we take from this? The first, statement of the obvious perhaps, cases turn on findings of fact. The second is trying to boil down a really quite a complex position to its core principle. Where the Employment Rights Act does not apply, the quasi-employer can owe a duty to the employee to provide an ethical working environment free of professionally unethical conduct, and can be liable for economic loss suffered by the employee post-employment. And that's the novel or the incremental element of the judge's findings in respect of the scope of a duty of care. A head office entity of a global network can take control of a local audit being carried out by a member firm, and so owe the audit duty, as found by the judge, to local partners and employees. It will simply depend on the facts. And UK entities dealing with local regulators abroad will need to be mindful that the English court will expect compliance with the IFAC code for accountants, and by parity of logic, other equivalent codes for other professions. So with apologies for my hiccup with the slides, that concludes my section of the talk.
Thanks very much, Ben. Got a couple of minutes left. If anyone wants to put anything quickly in the Q&As, then please do. here we go. So, question here, and it says, should there be a duty to provide an ethical working environment in cases where the ERA does apply? Well, I wonder whether that's perhaps one for Mike. I'd single you out here, Mike, given that this falls within the kind of context of the ERA. If you've got anything to comment on that one.
Yeah, my only first thought in relation to that is the one that would often apply. It's something akin to the Johnson exclusion idea, an employment law, which is essentially that where there is a statutory provision that allows for compensation. I'm happy to hear from Ben on this, but where there is a statutory provision that allows for compensation, the common law doesn't have a gap to fill in the way that the judge in this case was referring to the role of a tort cause of action at common law. So, you know, just in the same way you don't have the common law claim available or the contract claim available in the context of unfair dismissal generally, because we have such a wide-ranging and far-reaching regimen in Part 4A and in Part 10 for whistleblowing. And you heard me say that there was no cap on the damages available through both routes within the ERA system. To echo the language of Mr. Justice Kerr, there is no real gap to fill here in that sense. So I'm happy to be corrected or guided by anything that Ben has to say about my comments on that in that respect. But I don't. There is, you know, Mr. Kerr has it when he says that there is no gap to fill, and a UK person in scope under the provisions would be able to avail themselves of precisely what Mr. Rehan wasn't able to, and bring a claim, most especially now in the ever-increasing area of detriment open to the very widest range of individuals within employment law. I mean, employment law has a whole collection of definitions of applicable worker, and in section 43, I'm going to get the letter wrong now, 43K, I think. The worker definitions are so widely expanded that and the damages available are there. So we wouldn't need the tort claim. I think it's almost by parity of why it was needed for Mr. Rehan. It wouldn't be needed domestically.
Yeah, I think Mike's right in that at paragraph 576, the judge says that the court may be unwilling to allow the common law to develop in a manner that cuts across the content of a statutory scheme ordained by Parliament and occupying the same territory, Johnson and Unisys. So yeah, I think that one would hope that employees ought to be provided with an ethical working environment in which to work. But I suspect that the position that the courts would take is that that position already exists and is protected by the ERA. What you might not find in that situation, and this is where the sort of the nuance comes in, is that there's going to be a duty owed that has the effect of protecting against economic loss arising from post-termination loss of earnings. Although I think if this had fallen in with within the ERA, there would not have been a cap on the amount of the compensation claim.
That's correct.
Yeah, yeah. So you may get to a similar place.
Good. All right. Another question here. Do you think this judgment will have an impact on more whistleblowers coming forward, given the success of Mr. Rehan? I mean, I can take that initially, and perhaps I'd be interested to hear from Mike on that one as well. But I mean, I think the success of the claim and the level of publicity that it's had, I think, will or have an impact on whistleblowers coming forward. I mean, it is still that despite the success of this particular case, which I should say, and Ben no doubt would back me up, was very hard fought litigation over a number of years, you know, it was still very tough to get to that point where we were able to achieve some redress for Mr. Rehan. So and you know, the stakes are high for whistleblowers in terms of the sacrifices that they have to make. So I think there would that it should have some positive impacts, but I think there is certainly scope for more to be done. And Mike's already alluded to, well, referred to, for example, the time limits under UK employment legislation, which I must say seem to me to be extremely restrictive, and it must make it very, very difficult for whistleblowers to bring claims under those provisions, I would have thought, because I just cannot see how a whistleblower would have been able to appreciate the full extent of the impact on their life within 3 months, which is the time limit that would be applicable to them. But yeah, I'm interested to hear what Mike thinks about that one.
I mean, the limitation issue is one that all employment lawyers, we all feel this kind of sense of hard done to amongst our colleagues in civil law, in the sense we have such a short limitation period, and we seem to muddle along. Yes, people sometimes fall outside of it. There was a question asked in the Q&A a moment ago in relation, which I thought was interesting. I'm taking the liberty of responding to, because it's an interesting point, which was about Mr. Rehan having gone to the media. I think, again, there is detail on one of my slides in relation to this, in relation to this hierarchy of reportage. Hierarchy is the wrong word, the rules for reportage. There is provision there within Part 4A for exceptionally serious failure to be reported, including to the media, or rather, exceptionally serious failures are subject to lesser strictures in terms of to whom disclosures can be made and how. And I think in this particular situation, by the time Mr. Rehan went to the media, I'll be corrected on the facts by you guys on this, but by the time he went to the media, he wasn't only dealing with the baseline corruption issues in terms of the importation of gold and potential money laundering. He was dealing with one of the largest accountancy firms in the world, omitting to address the issues according to the relevant international regulatory framework, which of itself has a life of its own, as its own blood supply, as you say, alongside the originating wrongdoing. So I think that in those circumstances, I mean, it's always easy to comfortable to speak in a hypothetical sphere. Mr. Rehan would have been someone whose disclosures would have qualified for protection according to the exceptionally serious criteria within Part 4, had he been within the UK scope.
We almost get an answer to that, because it's a hypothetical answer, from the judgment itself, in this context of the causation arguments we had about whether Mr. Rehan had brought matters on himself by unreasonably resigning and unreasonably going to the media. And at paragraph 811, I think it's on one of my slides, that the judge says that he doesn't think, the judge who isn't very experienced in employment law, does not think it was unreasonable for Mr. Rehan to take that view. It was at least very strongly arguable that the disclosures were in the public interest. And then as for disclosure to the media being a last resort, in my judgment, the claimant can fairly say the point of a last resort had been reached. So although the judge didn't need to make a finding about that because the ERA didn't apply, I think his direction of travel was that it would have fallen within the ERA. Yeah.
Okay. Couple more here. Is the judge's view of this case as an outlier likely to influence future interpretations of the judgment? I mean, I can comment briefly on that and perhaps get Ben's view as well. I mean, in some ways, I think that comment, was based on the judge's interpretation that these facts were unlikely to reoccur. And when I talk about the facts, that includes the kind of the corporate structure and the way in which these defendants assumed control of these particular issues. But I'm not sure I necessarily agree that kind of type of scenario could not and would not happen again. I think it is certainly possible, given the way that organisations of this nature operate, in my experience. But I mean, obviously, the fact that he has said that in the judgment would no doubt be seized upon in defendants in the future to try to narrow the application of this judgment. Ben, I don't know if you had anything else you wanted to add to that.
Yes, I mean, I think it's an unusual situation in that the claimant was bringing a claim that the parties agreed was subject to English law against English law defendants, in the sense that they were LLPs and companies based in England, but the ERA didn't apply, and so that does seem unusual until you think about the global nature of professional services and other firms. I mean, it doesn't just have to be professional services that this kind of situation could arise. It could arise in any large multinational business. So I think it's a niche, if I can put it that way, but I'm not sure it's necessarily going to prove as unlikely as the judge anticipated. Time will tell.
Good. We're out of time really here, but there are two more perhaps we can try and deal with quickly. Regarding out of time, the first one is regarding out of time restrictions. What happens when a criminal investigation is taking place? Should a civil claim await the outcome, or should a civil claim be run and then held pending outcome of the criminal case? And given that we're talking about a civil claim as opposed to an employment claim here, Ben, do you want to deal with that one?
I mean, generally speaking, civil claims will be stayed pending the outcome of criminal proceedings. I mean, that's what I tend to find, certainly, that civil and disciplinary proceedings get stayed for criminal proceedings. So that's not that certainly, if you're acting for a respondent, that's not really terribly satisfactory very often, because it results in matters being put on hold for a very long time. But that's my experience.
And likewise in employment cases, the same.
Yeah. And then just finally, the final question: given that a breach of the accountancy profession's code of conduct was proven in this case, are there now disciplinary proceedings being brought in relation to the relevant accountants responsible for the breach? If not, is there scope for such proceedings in your view? Well, as far as I'm aware, there's been nothing has been made public, as far as I'm aware, in relation to disciplinary proceedings against the defendants in this case. But Ben, I don't know whether you.
Yeah, it's gonna. I mean, that would turn on among other things, whether they're regulated by the relevant institution in the UK, and whether what happened fell within the jurisdiction within the UK. So it just doesn't seem to me to automatically follow. I think it would, you'd have to. That would engage issues, I think, about what jurisdiction things happened in and what the jurisdictional reach was of the regulator.
Well, thank you very much to the panelists. Thank you, Ben. Thank you, Mike, and thank you to everyone who's attended today. Thanks a lot.
Thanks, everyone.
Thanks, everyone.